I have watched people misunderstand the law before. I have watched defendants quote legal phrases they found online, plaintiffs confuse opinions with rights, and angry litigants walk into my courtroom, convinced the Constitution was a magic shield against consequences. But I had never seen anyone walk up to the bench and try to teach the judge the Constitution, until Karen Whitfield entered my courtroom. And believe me, the courtroom reaction that followed was something I still remember with absolute clarity. Karen did not walk in like a woman facing a claim. She walked in like a woman arriving for a debate she had already won in her own mind. She wore a red blazer, oversized sunglasses resting on top of her blonde hair, and carried a thick binder pressed against her chest. The binder had colored tabs sticking out from every side: yellow, blue, pink, green. People often bring evidence to court. Karen brought a performance. Across from her stood Matthew Collins, a quiet middle-aged school security officer. He looked uncomfortable in his suit, like a man who would rather be anywhere else than standing in front of cameras and strangers. His hands were folded in front of him, and he kept his eyes on the floor. That told me something. Matthew did not look like a man seeking attention. He looked like a man dragged into a storm. The case appeared simple on paper. Karen claimed Matthew had violated her constitutional rights when he stopped her from entering a restricted school hallway during a PTA election event. She said he embarrassed her, blocked her freedom of movement, and treated her like a criminal. Matthew said he was following school policy after Karen ignored staff instructions and tried to force her way into an area where students were waiting for pickup. That detail mattered. Whenever children are involved, the courtroom listens differently. I asked Karen to explain her claim. She rose instantly, almost before I finished speaking. Then she opened the binder, not calmly, dramatically, like she wanted the whole room to hear the pages move. "Your Honor," she said, "before we begin, I think this court needs a basic lesson in constitutional law." The gallery went silent. Matthew slowly looked up. Even the bailiff turned his head. I stared at Karen for a moment, not because I was offended, but because I wanted to understand whether she truly believed what she had just said. She did. That was the disturbing part. She lifted one printed page and said, "The First Amendment gives me the right to speak, assemble, and move freely in public spaces." I said, "A restricted school hallway is not a public square." Karen smiled like she had been waiting for that answer. That's exactly the kind of misunderstanding I expected. A low murmur moved through the courtroom. I raised one hand and the room settled. Years on the bench teach you patience. People can be wrong and still deserve to be heard. But arrogance mixed with ignorance is dangerous because it turns correction into persecution. Karen was not listening for the law. She was listening for a moment she could twist. She pointed toward Matthew and said, "This man detained me illegally." Matthew's face tightened. I asked, "Were you physically detained?" Karen paused, only briefly, then said, "He stood in front of me." I looked at Matthew. "Did you touch her?" He said, "No, Your Honor. I asked her to return to the cafeteria 3 times, Karen snapped, "because you thought you could control me." And there it was, the real issue. Not constitutional law control. Karen had not come to court because she wanted the Constitution explained. She came because someone had told her no. Then Matthew's attorney opened a folder and said, "Your Honor, we have video from the school hallway." Karen's smile faded. Only slightly, but I saw it. The courtroom screen turned on. Karen looked at the binder in her hands, and for the first time, her confidence began to look less like knowledge and more like fear. The moment the school hallway video was mentioned, Karen Whitfield's fingers tightened around her binder. That binder had been her shield, her stage prop, her proof, at least in her mind, that if she used enough legal language, the facts would somehow become smaller. But facts do not shrink because someone quotes the Constitution loudly. They wait. And in court, eventually, they speak. I looked at Matthew Collins before the video played. His face was calm, but there was tension in his jaw. He was the kind of man who seemed uncomfortable accusing anyone, even someone who had clearly made his life difficult. That mattered to me. Some people come to court eager to destroy the other side. Matthew came wanting the truth to end the noise. His attorney explained that the PTA event had taken place at Westbrook Elementary School. Parents were gathered in the cafeteria for speeches, voting, and committee announcements. The restricted hallway led toward classrooms where children were waiting with staff until pickup. Corin was running for PTA vice president. That detail changed the mood of the room because suddenly Her behavior was no longer just about a hallway. It was about status. Karen had not been an ordinary visitor confused by a school rule. She was someone trying to prove leadership in front of other parents, and when Matthew stopped her, he did not just block her path, he challenged her image. I asked Karen, "Why did you need to enter that hallway?" She said, "Because I had every right to check on my child." A reasonable answer on the surface, but then I looked at the school sign-in sheet. Her child had already been signed out by Karen's husband 20 minutes earlier. I asked, "Was your son still in the building?" Karen glanced down. He could have been. Could have been, not was. Could have been. That difference matters. Truth speaks clearly. Excuses leave fog. Then the video began. The screen showed the cafeteria entrance, parents moving in the background, children's artwork taped along the wall. Matthew stood near a set of double doors with a sign that clearly read, "Staff and students, only Karen," appeared from the left side of the frame. Binder in one hand, pawn in the other. She walked directly toward the doors. Matthew stepped sideways, not aggressively, not suddenly, just enough to block the entrance. The audio was clear. "Mom, this area is restricted," he said. "Please return to the cafeteria." Karen responded, "You don't have the authority to stop me." Matthew remained calm. "I'm following school safety policy." Karen laughed. That laugh echoed through the courtroom speakers. Then she said, "You people need to learn the Constitution." A few spectators reacted softly, but I kept my eyes on Karen. She was watching herself on the screen, and for the first time, her courtroom confidence was fighting her recorded behavior. That is one of the hardest moments for people like Karen. They can control their story when it is spoken. They cannot control it when it is replayed. The video continued. Karen moved closer to Matthew, holding her phone near his face. "Say it again," she said. "Say on camera that you're violating my rights." Matthew took one step back, not toward her, away from her, that mattered. He was trying to de-escalate. Karen was trying to create a clip. I looked at the screen, then at the binder, then back at Karen, and I began to understand the pattern. This was not a misunderstanding of constitutional law. This was a woman using legal words as bait, hoping someone would react badly enough to make her look right. Then the video showed something Karen had not mentioned. A young student, maybe 7 years old, appeared behind the hallway doors. The child looked frightened by the argument. Matthew turned slightly to protect the doorway. Karen tried to step around him. The courtroom went still. Matthew's attorney paused the video. And in that frozen frame, the truth became painfully simple. Karen was not being silenced. She was being stopped from entering a restricted area with children nearby. I looked at Karen and asked, "Is that you trying to go around him?" She said, "I was asserting my rights." Then Matthew's attorney quietly said, "Your Honor." There is a second angle. Karen's face changed, and the binder in her hand suddenly looked very, very thin. The second angle came from a camera mounted near the hallway ceiling. It showed what the first camera could not, and sometimes that is exactly what breaks a case open. Not one dramatic confession, not one emotional speech, just another angle. Another perspective, another silent witness that does not care about ego, status, or performance. The footage began 5 minutes before Karen reached the hallway doors. She was standing near a group of parents in the cafeteria entrance, holding court in her own way. Her binder was open. Her phone was already recording. Several parents stood around her, some nodding politely, others looking uncomfortable. Then Karen said something that made the courtroom lean closer. "I'm going to show everyone how this school treats parents who ask questions." Matthew Collins was not even near her yet. That mattered. She had already decided she would be mistreated before anyone stopped her. That is a dangerous mindset in a courtroom. It means the person is not reacting to reality. They are hunting for proof of a story they already wrote. The video continued. Karen pointed toward the hallway and said, "Watch this." Then she walked toward the restricted doors. Not confused, not lost, deliberate. Matthew appeared from the side and blocked the entrance calmly. We had already seen that part from the first angle. But this angle showed Karen stepping closer than she admitted. It showed her shoulder nearly brushing his chest. It showed her phone rising toward his face before he ever raised his voice. And he never raised his voice. Not once. Karen had claimed she felt intimidated. The video showed her creating the intimidation. I asked Karen, "Mrs. Whitfield, did you tell other parents to watch before walking toward that hallway?" She shifted in her seat. "I don't remember saying that." The gallery reacted quietly. That answer has a special meaning in court. I don't remember often becomes the shelter people run to when no is too dangerous. Matthew's attorney then submitted a written school policy. Visitors were not allowed beyond the cafeteria during events unless escorted by staff. Parents had been notified by email the night before. Karen had received that email. She had replied to it. Her reply was short. This policy is unconstitutional. I looked at the document, then at Karen. You believed the policy was unconstitutional before you arrived? She lifted her chin. Because it was. No, I said. You disagreed with it. There was a difference, and everyone in the courtroom felt it. Disagreement is not oppression. A rule is not illegal simply because it inconveniences you. But Karen had built her identity around that confusion. Then Matthew took the stand. His voice was steady, but his hands were clasped tightly in front of him. He explained that he had worked school security for 9 years. He had 2 children of his own. His job was not to argue with parents. His job was to keep restricted areas safe. He said, I knew Mrs. Whitfield from previous meetings. She often challenged staff, but that day felt different. She looked like she wanted me to stop her. Karen scoffed. I looked at her. She stopped. Matthew continued. When I saw the phone, I knew she wanted a reaction, so I kept my voice low. That detail impressed me because real professionalism is not shown when people are polite to you. It is shown when they provoke you and you still refuse to become what they want. Then the attorney played the audio from Matthew's body microphone, used by school security during public events. Karen's voice came through clearly. If you touch me, I'll own this district. Matthew answered, I'm not touching you, Mom, she said. Then move. He replied, I can't allow you into a student area. Then Karen said, good. Keep talking. This is exactly what I need. The courtroom went silent because in that sentence, the performance became visible. Karen was not being denied a right. She was collecting material. And as the recording continued, another voice appeared in the background, a child's voice, small, frightened. Why is that lady yelling? Karen looked away from the screen, and I knew the case was about to move from embarrassing to unforgivable. That small child's voice changed the courtroom more than any legal argument Karen Whitfield had made. Why is that lady yelling? The words were simple, innocent, unrehearsed, and sometimes those are the words that cut through the deepest layers of performance. Karen had entered my courtroom with a binder full of highlighted pages, pretending this case was about the Constitution. But the video showed something much clearer. A grown woman had walked into a school event, aimed her phone at a security officer, ignored a restricted area policy, and turned a place full of children into her personal stage. I looked at Karen and asked, did you hear the child in the recording? She did not answer directly. Instead, she said, children hear adults disagree all the time. That answer disturbed me. Not because it was loud, because it was cold. There was no concern, no pause. No recognition that her conduct had frightened the very children she claimed she was defending. That is when I knew Karen was not confused about the law. She was using the law to avoid empathy. Matthew Collins remained composed, but I could see the emotion behind his restraint. He had been accused publicly of violating rights, intimidating a parent, and abusing authority. Yet the evidence showed he had done exactly what a school security officer should do. He stayed calm. He protected the hallway. He refused the trap. Then the school principal, Rebecca Hayes, took the stand. She was a serious woman in her 50s, with the exhausted dignity of someone who had spent years managing parents, staff, and emergencies without ever expecting to become the subject of a courtroom spectacle. She testified that Karen had been warned 3 times before the event not to enter restricted areas. She also said Karen had sent emails threatening to turn the PTA election into a constitutional crisis. That phrase made the gallery stir. A constitutional crisis. Over a school hallway, Rebecca handed over printed emails. One message from Karen said, if your staff blocks me, I will make sure the entire district sees what kind of authoritarian system you are running. Another said, I know how to make things go viral. There it was again. Viral, that word has changed so many disputes in recent years. People no longer only want to win arguments. They want strangers to validate them. They want a clip, a headline, a moment. And sometimes they're willing to bend truth into something ugly just to get it. I asked Karen, did you intend to post the hallway footage online? She said, I intended to expose government overreach. I said, at an elementary school? She flushed with anger, but she did not answer. Then Matthew's attorney presented the next item. A draft caption Karen had prepared before the event. It read, "PTA mom blocked by school officer after quoting the Constitution. Watch them panic when parents know their rights." The courtroom reacted instantly, because the caption had been written before the confrontation. Before Matthew blocked her, before any alleged violation occurred, Karen had not documented what happened. She had staged what she wanted to happen. I watched her stare at the caption on the screen, and for the first time, the binder did not help her. No amendment could explain the timing. No highlighted page could erase the intent. Then Rebecca Hayes said quietly, "Your Honor, there is one more recording." Karen's head turned, sharp, fearful. Rebecca continued, "It was taken in the parking lot before the event began." Karen whispered, "That has nothing to do with this." But I knew from her face that it had everything to do with this. I allowed the recording. The screen went dark for a moment. Then Karen appeared beside her SUV, speaking to another parent. Her voice was clear. "If Matthew stops me, perfect." He's the face of the lawsuit. The courtroom froze, and Karen's hand slipped from the binder like she finally understood the Constitution could not save her from her own words. There are moments in court when a person's own words become the witness they cannot intimidate. Karen Whitfield had spent the morning trying to teach my courtroom the Constitution. She had waved printed pages like weapons. She had accused Matthew Collins of violating her rights. She had told everyone she was standing up for parents, but the parking lot recording said something very different. "If Matthew stops me, perfect. He's the face of the lawsuit." The courtroom did not simply react. It changed. Prints in the gallery turned toward one another. Matthew lowered his eyes, not in defeat, but in the quiet pain of a man realizing he had been selected as a target before he even spoke. Rebecca Hayes sat stiffly, her face pale with anger she was trying very hard to control. Karen looked at the screen as if she wanted to argue with her own voice. I asked her, "Did you say that?" She pressed her lips together, no answer. I asked again, "Did you plan to use Mr. Collins as the face of a lawsuit before he stopped you?" Karen finally said, "I knew they would violate my rights." That was not an answer. It was the story she had come to sell. Then the recording continued. The other parent asked, "What if they don't stop you?" Karen laughed. "Then I'll keep pushing until they do." A gasp moved across the room. That was the moment the case exploded, because in one sentence, Karen revealed the entire strategy. She had not been prevented from exercising a right. She had been searching for a confrontation. She had not walked toward that hallway to check on a child. She had walked toward it to create a defendant. Matthew's attorney paused the recording. But the damage had already been done. Karen suddenly stood and pointed at the screen. "This is why people don't trust courts. You take one sentence and twist it." I looked at her calmly. "No, Mrs. Whitfield. The court is playing the full recording." And then I allowed it to continue. Karen's voice came again. "I don't need to win the election if I win the narrative. Parents are tired of being told no." That sentence sat in the air like smoke. Not justice, narrative, not safety, attention. Not constitutional principle, control. I looked at the binder she had brought. Thick, color-coded, carefully arranged. But not one page in that binder could change the truth now. She addressed personal ambition as legal principle, and the courtroom had watched the costume fall apart. Then came the final part of the recording. Karen said, "By tomorrow, everyone will know Judge Judy let school staff violate a mother's rights." Rebecca Hayes looked stunned. Matthew's face hardened. And even I felt the room tighten around that sentence, because Karen had planned to involve the court before she ever entered it. She had already written the story, already chosen the villain, already chosen the headline. She did not want a hearing. She wanted content. I turned toward Karen and said, "You did not come here to learn the Constitution. You came here to misuse it." Karen's face twisted with anger. "You can't say that. I just did." The gallery went silent again, and then, from the back row, one parent stood up and asked if the court could hear what Karen had told other PTA members before the event. Karen shouted, "No." That shout confirmed what the request only suggested. I allowed the testimony. The parent, Allison Parker, stepped forward. She was nervous but determined. She said Karen had urged several parents to record, share clips, and comment online before the event even happened. Then Allison produced a group chat message from Karen. It read, "The goal is to make them react. Once they react, we win." That was the viral moment, not because Karen looked powerful, because the whole courtroom finally understood how carefully she had tried to manufacture outrage. Matthew Collins had not violated her rights. He had refused to become the villain in her performance. I looked at Karen one last time before ruling. Her binder was closed now. Her face was red. Her hands were trembling. And for the first time since she entered, she had no lesson left to teach. I have often said that the Constitution is not a costume. You cannot put it on when you want power, remove it when facts appear, and wave it in front of people as a shield for behavior you already know is wrong. Karen Whitfield sat silently now, her binder closed in front of her. That was the image I remember most clearly, not the shouting, not the accusations, the closed binder. Because it symbolized the end of the performance. Matthew Collins stood across from her with the quiet expression of a man who had been publicly attacked for doing his job. He did not look happy. He did not look victorious. He looked relieved. There is a difference. Relief is what honest people feel when the truth finally catches up to the lie. I dismissed Karen's claim in full. Then I ruled in favor of Matthew's counterclaim for reputational harm, legal costs, and documented damages caused by Karen's public accusations. I ordered the recordings, messages, and group chat evidence forwarded to the school district and appropriate authorities for further review. Doreen finally looked up. So parents have no rights now, she said. That was her last attempt. One final twist. One final headline. I looked at her and said, parents have rights. But rights do not allow you to ignore school safety rules, provoke staff, frighten children, and manufacture a lawsuit. The courtroom stayed silent, not because they disagreed, because the sentence had finally named what everyone had witnessed. Karen had tried to turn a restricted hallway into a constitutional battlefield. She had tried to turn a security officer into a villain. She had tried to turn ordinary school safety into oppression. But the evidence did not let her. Rebecca Hayes wiped her eyes quietly. Matthew nodded once, almost to himself. Alison Parker stepped back into the gallery, still nervous but visibly lighter, and Karen sat there with nothing left but anger. I told her, the Constitution protects citizens from unlawful government action. It does not protect staged misconduct from consequences. She stared down at her binder. For once, she did not interrupt. That silence mattered, not because it meant she understood. Some people do not learn from consequences. They only resent them. But court is not built to guarantee remorse. It is built to establish truth. As the hearing ended, Matthew gathered his papers slowly. Before leaving, he glanced toward the gallery, where several parents sat. Some of them had believed Karen at first. Some had shared her posts. Some had repeated her claims without knowing the facts. Now they looked ashamed. That is another lesson from this case. Outrage spreads faster than truth, but truth has something outrage does not. Well, when truth finally lands, it stays. Karen walked out of the courtroom with her binder pressed against her chest, but this time she did not look like a woman leading a movement. She looked like a woman carrying evidence of her own failure. And Matthew Collins walked out with his name restored. That may sound simple, but for a working man accused of abusing authority in front of parents, staff, and strangers online, a restored name is not small. It is everything. I stayed on the bench for a moment after they left, because some cases remind you what the law is really fighting against. Not just lies, performances, manufactured outrage, people who learn a few legal phrases and use them not to defend justice, but to avoid accountability. Karen Whitfield wanted the courtroom's reaction to go viral. In a way, it did, but not because she taught anyone the Constitution. It went viral because everyone watched a woman discover that quoting rights is not the same as respecting truth. And that is the lesson I still carry. The law is powerful. The Constitution is powerful. But neither one belongs to the loudest person in the room. They belong to the truth. And on that day, truth did not shout. It simply closed the binder.